And the Game of Thrones continues in Karnataka. Well, at least the Supreme Court has given us its decision, and this is where we stand right now. The Supreme Court has decided and directed that the floor test in the Karnataka Assembly is to be held at 4 p.m. tomorrow, which gives and completely shortens the time that B.S. Yediyurappa would have thought he had. He thought he had 15 days from the date of his swearing in, but he now has 48 hours from the date of the swearing in and only 24 of those hours left now in which they have to cobble together the strength. As of now, both the BJP and the Congress JDS coming out to say that they are ready for the floor test and they will prove their majority on the floor. I have with me Mr. Aryama Sundaram, senior advocate of the Supreme Court and very eminent legal voice. Mr. Sundaram, thank you so much for joining us here on Mirror Now. I appreciate your time. We've talked about this particular problem being faced in Karnataka a couple of times already, and you were of the opinion that the coalition with the numbers in hand should have been called to or should have been invited to form the government. But now the Supreme Court has given us some clarity at least. What is your reaction, firstly, to the order that we've received today?
Well, I think today's is a very pragmatic, practical order. And it's an order which tries to sort out what is really a very bad situation. The fact of the matter is very grave doubts have been placed on the manner in which the governor acted, very grave doubts on his calling on a party whose only way to come to power is by forcing a violation of the Constitution, a violation of the 10th schedule of the anti-defection law, and that was the only way they could come to power. And the governor then called that party. The only way that party could have come to power is through violating the Constitution. Governor asked that party to come and gives them 15 days to violate the Constitution. The Supreme Court was actually placed with a very piquant situation that night during the night hearing. What was sought for was a stay of the swearing in. Now the fact is we have to understand one thing. The president and the governor have constitutional immunity. When they're discharging their constitutional functions, you cannot in any manner prevent them from doing so. However, their actions are subject to judicial review, and you can take any decision and quash actions taken by them. But you can't prevent the carrying on of a constitutional function. And one of the constitutional functions which the governor was carrying out was that he was going to swear in a chief minister. So the court basically, I think, went on the basis we can't stop him from doing that constitutional function, but at the same time, his action of calling on them is a matter which is subject to judicial review, number one. Number two, once a new person has taken office, his right to continue in office is a matter for judicial review. As to whether he should take a floor test and how soon he should take a floor test is a matter for judicial review. So in that manner, the court posted the case to today, and since there were claims made that day which the court couldn't decide, where Mr. Yediyurappa's party claimed to have the support of a whole list of 117 people, and that was not before the court the letter Yediyurappa gave. They said produce the letter today, and the BJP came a cropper because they couldn't produce the list of supporters in such a letter. So the Supreme Court has dealt with it in the wisest fashion possible. Just look at the directions they've given. I think it is such a pragmatic way of dealing with it. Number one, there is going to be an attempt at horse trading. We can't be blind to it. It's going to happen. Therefore, let's minimize that. Let's minimize it to the maximum possible, and let's floor test within 36 hours. Now, that is a very strong order, and that's a very strong reflection on the governor's initial order by which he said 15 days. You virtually reversed that order of the governor's. Governor's order giving 15 days has been reversed by the Supreme Court, and what they've said is now the shortest time to prevent horse trading to the extent that it can be prevented. Number two, make sure that there is a pro tem speaker. So there is no question of any wriggling about the speaker's appointment and partisan people becoming speakers, etc. Number three, make sure the legislators are sworn in, because then the anti-defection law without doubt kicks in, although in my view even earlier it would. But without doubt, once they're sworn in, it kicks in. Number four, this BJP's request for secret ballot cannot be there because we don't want underhand dealings. Let's have an open ballot. It shall be by a show of hands. There will be no secret ballot. And number five, this man who's occupying that position is in grave doubt even now, cannot take any policy decisions. Number one. Number two, he cannot try to support his own success in a floor test by appointing the Anglo-Indian member, which otherwise the government is entitled to appoint. I think what the Supreme Court has done is a very clear thing. They say we take the situation as it stands today, prove your majority. Not, we are going to give you time to do the defections and then be able to show your strength, to show us that today you have the strength. And that's what the Supreme Court has done. And I think, and lastly, don't forget, the question of the legality of calling them to form the government has still been left open, and that will be decided. I think it's an excellent decision in the circumstances of the case, and I can't really, however much I try to think, I can't think of any different kind of decision which could practically, to the best possible way, resolve the situation. And I'm just not able to imagine what else could have been done, because I really think there's a very pragmatic, practical way of dealing with the situation.
Mr. Sundaram, when Abhishek Manu Singhvi stepped out of the court to speak with the press, he said something very interesting. He said that this is an interim order right now, and the court will continue to examine the validity of the governor's decision to invite Mr. Yediyurappa to form the government. Now, which means that from a Supreme Court's point of view, this isn't over. We also know in the arguments that were made, Justice Sikri asked Mukul Rohatgi, he gave him two options. He said either we can set right the rules and the law right now, or you agree to a floor test. So would you say that going forward in the next few weeks, when the court reconvenes on this particular case, that we might actually have a precedent in place as to what rules or what guidelines need to be followed when making these decisions?
Look, Faye, I've always maintained that in cases like this, there cannot be any guideline which is cast in stone. The basic underlying guideline is in the Constitution itself. What is demanded is the person there must have the support of the majority of the House, coupled with the fact that that majority cannot be cobbled together through getting people to defect in violation of the 10th schedule. It is that the governor should ensure that the person who, to his eyes, commands that majority at that given time when they come before the governor, at that given moment, should be asked to form the House, and then to make sure that there's no error in that, should be asked to prove his majority in the floor of the House at the earliest possible. If you look deeply into all the judgments of the Supreme Court, Bommai, Rameshwar Prasad, everything, this is exactly what they're saying. Sarkaria Commission's guidelines were also based on uncertainty. But when there's certainty at that given moment, it is always possible that later on some may go and some may come. That's also possible. But what the governor has to do is, at this given moment, is there someone who this second as they speak to me certainly commands the majority? If the governor feels that is so at that given moment, he asks them to form the government and to then take a floor test within a given period of time. If, however, the governor is uncertain at that time, there are various ways to do it, and that is where the Sarkaria Commission, Rameshwar Prasad, all these have already given the guidelines, so I don't see any further guidelines. What is very interesting is, if the Supreme Court is going to decide on the legality of calling Yediyurappa to form a government, it forms a very interesting situation. I ask myself, what is going to be the issue? Assume for the sake of argument, that Yediyurappa forms a majority, is able to prove his majority on the floor tomorrow, and therefore continues. Now look at the two situations which could arise. Number one, assume that the Supreme Court thereafter on the law finds that he could never have been asked or never been asked to form the government in the first place. Then what happens? Even though he has the majority in the House today, is he removed? So that Arunachal Pradesh is a pointer, because what the Supreme Court did was to set the clock back and restore the status quo as it was before. Now that is a possibility. Whether it's done, not done, we can never say, not comment on. The other interesting issue which strikes me as a big lacune in the Constitution and in the anti-defection law is this. When the whip is issued, when somebody is standing and wants his majority decided and is going and has moved the trust motion. Now if the whip is issued and people vote against the whip, they vote against the whip, and therefore the person who is seeking the trust motion stands. Stands, and he then succeeds in the trust motion. What happens? Immediately thereafter, those who voted for him are disqualified from the House.
Yes.
Now look at this situation. Let's just count numbers in Karnataka. We have 221.
Yes.
Let's say 104 BJP,
Yes.
2 independent, they will never lose their seat. So let's assume both of them vote with BJP. Let's assume BJP gets 8 people across. So BJP has 106, or they need what? 112. So let us say they get 6. So they get their 112. Now those 6 immediately thereafter stand disqualified by
Yes.
the 10th schedule. Now the strength of the House has come to 215.
Yes.
In 215, his 104 and plus 206 is still not 50% of the House.
Yes.
So what happens? Can a no confidence motion be moved against him by the then existing members of the House? Or do they have to wait for a by-election? And after those are filled in, thereafter, if he doesn't have the numbers, move a no confidence. So, you know, these are really grey areas. I feel that this issue of allowing the vote of the person defying the whip to be counted and thereafter disqualifying him is something I think needs a look in the long run. But today, as our constitution stands, that's the way it is.
And Mr. Sundaram, if you look at the numbers right now, and you're right, we're at 102, we are at 221 because Kumaraswamy contested in 2 seats. He won both seats, so he's required to vacate one of those seats, and he technically can't vote as 2 people, so he only that's 1 vote. And the BJP has 104 plus 1. We know for sure it could be plus 2 as well. One of the options here would be to get MLAs to abstain or resign. They're, disqualifying them. They would have to get at least 14 people to either abstain or resign, thereby bringing down the numbers so that their number of 105 becomes the new halfway mark. Is that an option?
Correct. Correct. That is my point. It's a very interesting situation because tomorrow, by getting 6 Congress MLAs and 2 independents, he will win the trust motion. But once those 6 MLAs are thereafter disqualified, strength of the House is 215. Now 104 plus 2 independents is 106, which is not 50% of 215. So this is, like I said, this is a very grey area in the Constitution itself, because basically you're saying under the 10th schedule you stand disqualified if you vote against your party. However, the vote which you cast will be taken into account. Now that is how it stands, because after all that also makes sense, because until you've cast the vote, how can it say you've been voted, that you voted against the party? But I'm looking at it another way. Assume that you cast the vote and then if it was against the party, your vote is not counted. Well, maybe that is a way, but that would require a constitutional amendment. That's not something which is... but I'm saying this is a bit of a grey area which we find time and time again. We find this in various states when this kind of disqualification happens, because we found Uttarakhand there was disqualification, Tamil Nadu there's been disqualification. You know, in various states there has been disqualification. Yadurappa himself is the name behind which one of the judgments of the Supreme Court comes as to whether there was a disqualification, valid disqualification or not. In that case, in the case of Yadurappa, the Supreme Court said no, they were not disqualified because they did not leave the party, they only asked for something. So these are all grey areas. But what I'm concerned about is the example I gave you. What happens there?
Absolutely. And Mr. Sundaram, the other point that you did bring up was the fact that the court has decided to instruct the DG Police of Karnataka to provide protection to all of the MLAs of the 2 parties, Congress and JDS, because the lawyer representing the Congress said that they fear for the security of their MLAs, and their security was pulled this morning after Yadurappa became Chief Minister. One of his first decisions was to remove the security from the Eagleton Resort where all of these MLAs had been housed. Now, has this fight really turned into a street battle at this point? But the Supreme Court has taken cognizance of the problem of security. All right, we've lost the audio connection with Mr. Sundaram. We will try and get that back. But Mr. Sundaram bringing out a brilliant point here, viewers. And my team's working on the charts and the numbers, so we'll be able to show it to you on your screen. But stay with me. This is what he said. He said, without Kumaraswamy, we're now without Kumaraswamy's 2 seats. So he only has to vote in 1. So we're at 221. Now, this is what he was talking about. Now, of 221, we know 104 with the BJP for sure. Now, there are two independents who do not come under the anti-defection law because they're not part of any party. They can vote any which way they please. Let's assume, for argument's sake, that they both vote with the BJP. That takes the BJP up to 106. Now, let's also assume, for argument, that the BJP manages to get 6 or 7 MLAs to vote in its favor. What happens? Their numbers now have gone up to 112 or 113, safely past the halfway mark. They vote, the BJP wins the confidence motion, wins the show of strength. But those 6 or 7 MLAs would be immediately disqualified thanks to the anti-defection law. And the strength of the House will come down again. Now, once the strength of the House comes down again, even then, the 106 will not be past the halfway mark, which means that once that happens, even after this hurdle is crossed, there could still be a no confidence motion which the government would lose, and this could go on for a while. So it doesn't seem fully here, completely rounded in, and this is not, so tomorrow might not be the end of it. What the BJP needs to do clearly is to get at least 14 or 15 MLAs to abstain or to resign by tomorrow. 14 or 15 MLAs from the Congress or the JDS faction to either resign or to abstain tomorrow. That is the only way the BJP, with its current strength, would comfortably be able to hit the halfway mark and stay there and not drop below that halfway mark when the numbers change again after the disqualification of MLA. So that's effectively what Mr. Sundaram was telling us. It's a brilliant angle. Okay, so do we have that audio back in again? Mr. Sundaram can hear us. Mr. Sundaram, the court took into cognizance the Congress and the JDS's plea for security and chose to instruct the DG police to provide that security. What can we read into that?
What I can read into it is a very sad state of affairs where, you know, to hold office, politicians would even resort to violence or to strong arm to prevent people to come to the legislature. So I think it really reflects very sadly that political parties have to ask for police support, police help, police security to ensure their safety to be able to vote, and or that another political party is doubted enough to have to be directed to provide it. So I think it's very sad, but it's a reality. What to do? That's where we are with politics today.
Also, the pro tem speaker who's going to be chosen tomorrow, if we go, and my team was just looking at the details, if we go with the process, which is to pick the senior most member of the assembly, someone who has served in the assembly for the longest time, I believe that individual is a member of the Congress party. Would you think that would cause a grey or some sort of disruption as well?
Look, I think we've got to accept one thing. The office of a speaker is an enormously respected office. A speaker is the master of the house. He's the king of his castle. And the speaker is meant to be absolutely impartial in the discharge of his functions. So, constitutionally, once you occupy the office of speaker, you have no party, which is why the speaker also doesn't usually vote except in very few circumstances. So you don't really belong to a party, so to speak, and you are partyless. That is why historically, conventionally, when there's a requirement of a pro tem speaker, the choice has always been the senior most legislator. Because the senior most legislator is a person who's seen a lot over the years, who's seen various situations come and go, who has now, let me say, been weathered enough for the situation that he can actually carry out the functions. Fortunately, tomorrow, in many ways, the discretionary role given to a speaker has been cut down a lot by the Supreme Court directions. For example, the legislators shall first be sworn in. So there's no question tomorrow as to whether they're already legislators and the whip will apply or not apply, etc. Legislators will be sworn in because only then will can the trust vote be taken. Number two, that it is to be by a secret ballot. Now take the case of a speaker. What's his role tomorrow? His role has been very clearly cut out. One, swear in the legislators. Two, conduct a floor test. Three, the manner of conduct of a floor test has also been decided. It's not for you to decide whether it's a secret ballot or a show of hands. It shall be a show of hands. So his role really is to sit there, call for the floor test, and thereafter the counting will be done by the senior members of the legislature, officers of the legislature, the legislative office, who will count, and then he declares the result, and law takes its course. So I don't think tomorrow the fact that a person is occupying that office of speaker ought to count for too much, unless there's a strong arm tactics adopted, etc. And there again I find it a bit unlikely, because you see, it's Yediyurappa who is to prove his strength at the House. Now, if for any reason there's something conducted by which he is prevented
but
from
here's a different question, Mr. Sundaram. Here's a different question.
Not being able.
On the role of the pro tem speaker, now we understand that Mr. R.V. Deshpande is the senior most leader in the assembly right now. He's a member of the Congress. The second recommendation is for Umesh Katti of the BJP. Now, my question to you is, do you believe the pro tem speaker will vote tomorrow? If he does, then that's one vote. If he doesn't, then will that cost his side a vote?
Look, I think the pro tem speaker, in a matter like this of the confidence vote, if his vote is to count and make a difference, can vote. That is my reading of the situation, and that's my understanding. That he, in the normal count, now if one or the other has succeeded on its own terms and his vote doesn't count, it wouldn't be there. But assume there's a deadlock between the two, that it's an equal and one vote matters, then I think he will be called upon to vote. Definitely, yes.
Because at this point, obviously, every single vote is going to count, and that would also weigh in for both parties if one of their members is going to be pro tem speaker. So they'd want to know whether or not that vote would come into play, or would they be sacrificing that vote by, when the person gets appointed as pro tem speaker. The other question, yes, go ahead, please.
No, I said they won't be sacrificing the vote.
They won't be sacrificing a vote.
Because otherwise, why would the BJP want a pro tem speaker from their party?
The other question I must ask you is, of course, the Supreme Court did take into consideration in the late night hearing. We were tracking it very closely here at Mirror Now. We were up all night, and one of the observations that one of the judges made was, what do you need this much time for? How are you going to get these extra MLAs on your side? Are they suitcases exchanging hands? This was the question. There was a mention of suitcases. So the court has taken into account the fact that the switch of sides cannot happen in any other way other than an unethical and perhaps also illegal manner.
Correct. Which is why the court has restricted the time and said that have the floor test by tomorrow. That's why I said this is a case to minimize the damage. This is the most pragmatic decision to minimize the damage in the given situation. There is unfortunately a situation which was created by this governor. And this governor, having created such a situation, the Supreme Court has to sort it out in the most pragmatic manner possible. And I think that's why I started by saying it's an exceedingly pragmatic decision. And however much I tried to think about what could have been said differently or could any other direction have been given, I really can't even think of one thing. I must say that it's a decision which has covered all aspects of the matter.
Well, I have one last question for you, Mr. Sundaram. Obviously, there is a question of the governor being a central government employee and the central government appointee, I beg your pardon. And this is what the Congress has harped upon for this entire conversation, that he is actually behaving like a puppet of the ruling party in the centre. Do you actually believe that to be true? And do you think that perhaps even the appointing of the governor, the process needs a relook?
Well, all I can tell you, Faye, is the framers of our constitution, when they planned the office of the governor and gave the governor such great importance, gave him such powers, and don't forget in the warrant of precedence how high he ranks in the, I think if I'm not mistaken, the governor is just next to the speaker in the warrant of precedence. I think the framers of the constitution were looking at people like Padmaja Naidu, Jayachamaraja Wadeyar and people to be the governors. Today, unfortunately, the office of the governor has been an office given to an old party loyalist who has now gone past the stage or usefulness of active politics and is really sent out to pasture with a pat on his head for services rendered to the ruling party of the day. And that is a fact. How many decisions of governors have to be overruled? Look at the Supreme Court, Arunachal Pradesh, other places, decisions of the governor are being overruled. And look at this instant issue here. Look at the whole situation created. I don't think too many people, let me be very frank with you, whichever party you are in, or a person like me who's in no party, any layman would wonder whether, I think if we really did a poll and said, do you think the governor here acted at the behest and in the interest of the BJP? I believe if you took a poll, that poll will be 95% saying yes. So I think the proof of the pudding is in the eating. And unfortunately today, this is not just one governor, but I find there are a lot of situations where the governors are really, giving effect to their master's voice. And before they take a decision, the call is to Delhi. And I think that's a very unfortunate situation. And I don't think the framers of our constitution ever expected that this is what the office of governor could become or be seen as, or have somebody like me comment as being seen as that. I don't think that was ever the intention.
But is there a better way, Mr. Sundaram, of picking the governor then in that case? Or do you think it deserves a re-look at this point?
Look, the point is, whatever we say, finally it is the people of India. It is us. You can give us a beautiful document of the Constitution and we can utilize it in such a manner or violate it in such a manner. Finally, it boils down to us and the way we behave. And unless all the wings of government, of the state, act in a manner which befits what is expected of them, I'm afraid that, you can give any great document, but finally, it's the way the citizen behaves. And if the citizen doesn't decide to behave in a manner befitting his status, well, it's a very sorry day. I'm just hoping that there's still hope. There's a whole new young generation which I believe is going to come in and have great belief in what our forefathers have given us.
All right, Mr. Sundaram, many thanks for joining us here on Mirror Now and sharing your thoughts. Aryama Sundaram, the brilliant legal mind, sharing his thoughts on the Supreme Court judgment that we've just heard. While we thank Mr. Sundaram, we also